Hey folks, hey, I did not expect this to be televised. I really didn't. So I didn't even look for it. And then it popped up. So, okay. Yeah. And we are going right into it. And it's been going on for 15 minutes. So we are not missing much. Everybody, share it where you can. No, this is not in front of Judge Gould. This is in front of the Supreme Court in order to have the lawyers reinstated and also maybe getting Judge Gould off the case. So that is what this is about. As I said, I didn't think this was televised. Yeah, surprise live. But no, yeah, let's go right into it. Let's. No closed captions, but I think we will be all right.
We're here this morning to argue in the case of State ex-rel Richard Allen, relator, versus Carroll Circuit Court and the Honorable Fran M. Gall, respondents. Counsel for Richard Allen, the relator, will argue first. We're hearing this case on a writ for mandamus and a prohibition case. Representing the relator today, we have Mark Lehman. Good morning and welcome, Mr. Lehman. You'll be arguing the case. At council table, we also have Kara Winnecke. Good morning, Ms. Winnecke, and Bernice Corley. Good morning and welcome, Bernice Corley. Representing the state of Indiana, at council table, we have Angela Sanchez. Good morning, Ms. Sanchez, and welcome. You'll be arguing first, correct? Second, all right. You're just listed first on the appearance. Got that. So Matt Gutwein, representing Judge Fran Gall, and you will be arguing first. In a council table, we also have Chris Stake, who's also here on behalf of the respondent. Correct. Good morning and welcome, Mr. Stake and counsel. Counsel, as we've been conducting oral arguments, you'll each have about 2 minutes before we may start asking questions. Each side has 30 minutes. So you ready to proceed?
I am.
All right, Mr. Lehman.
Good morning, Justices. No Indiana court has tolerated a trial judge removing a lawyer from a case over the client's objection based on the judge's subjective belief the lawyer is negligent or being ineffective. Cases across the entire country do not tolerate the removal of the entire defense team from a case over the client's objection where the lawyer is licensed in the jurisdiction and prepared for trial on the scheduled date. When a judge severs the attorney-client relationship over the client's objection, the integrity of our entire judicial system is undermined, and the unauthorized action necessitates that this court intervene and invoke its inherent authority to supervise the conduct of lower courts. On October 12th, the judge ordered counsel to, quote, cease work on Mr. Allen's case until we meet on the 19th. This was a period where intensive work was occurring in the case, where Mr. Allen and his lawyers were in the middle of tactical decisions and strategy review. This impined the right to counsel. When October 19th rolled around, the judge took clearly coercive action to sever the attorney-client relationship on her own motion. The judge was without jurisdiction to sever the entire defense team over the objection of Mr. Allen's wishes. And his licensed counsel, who both remain in active and good standing in our state.
Without jurisdiction? Explain that. Why was the judge without jurisdiction?
Judge, I think the judge here exceeded her jurisdiction when she refused to accept Rick Allen's wishes when she had an absolute duty to act upon them. And the judge crossed the barrier of neutrality and entered the realm of being an advocate. And when the defendant is saying, this is what I want, this is what I desire, that the judge is without jurisdiction and has an absolute duty to act upon the client's wishes under those circumstances.
So isn't your argument more accurately phrased that she's under a duty to let them back into the case? It's not a question of court's jurisdiction being exceeded, is it?
No, Judge, I see those as one and the same.
Are you talking about authority or jurisdiction? I mean, we have a lot of cases that define both of those differently.
Judge, I think that under either construction, and I see this as the judge is without authority, or excuse me, the judge is under an absolute duty to act upon the wishes of the defendant under these circumstances.
Okay, but you don't cite a lot in that. So when you talk about absolute duty, a court, we have cases that say courts can remove counsel for various reasons if they're not a member of bar, if there's a conflict that really is to the detriment of the client. So there's not an absolute duty to always leave counsel on, correct? There is some discretion the trial court judge has.
There's an absolute duty to follow the client's wishes. And then when a conflict of interest arises, the issue is whether the client fully understands that whether he's making a knowing and voluntary decision.
And the absolute duty is found under the Sixth Amendment?
Judge, I think the absolute duty could just be under this court's case law, but I think that in the aggregate, that the three violations of the Sixth Amendment provide this constitutes three situations where in their totality, they clearly placed a limit on the judge.
Is there a reason why you didn't file a state constitutional claim? I was sort of surprised by that under Article 1, Section 13.
Judge, we didn't feel like we had the record to preserve that issue and developed a separate argument under the Indiana Constitution. But we're not arguing that this court isn't free to proceed under that analysis. We had basically 5 or 6 days under a situation where the judge wasn't even giving us a transcript to see exactly what took place within that
You have a lot of concerns, but I've got a couple. You've got a lot of concerns, and you do a nice job laying those out in your brief. But there's a couple of things. You're asking the court to issue a ruling for a speedy trial. It appears Mr. Allen signed that with his attorneys in August, but they had never filed it. So, correct?
Yes, I think when he signed it, they were outside of the 70-day, but the speedy trial was.
But you acknowledge that you're asking us to grant something that wasn't requested at the trial level.
Well, it wasn't requested at the trial level, Your Honor, because it wasn't necessary until October 31st when the judge removed them the third and kind of final time.
So they sat on it they had it for 2 months and didn't file it. Your client signed it in August under the.
Yes, Your Honor. They had it and did not file it. One, there wouldn't have been a reason to file it. They had it made. So the speedy trial was an intimate part of their strategy here, and they had developed strategy and tactics with Mr. Allen as to when specifically to file that. The request for the completion of discovery was granted by the judge. That deadline was submitted or ordered by the court to be November 1st. And then the tactic there would have been to file for a speedy trial right after that to lock in the trial date and to close down the evidence that the prosecutor can then introduce at that point. But Your Honor, that request is because it's the relief that our client wants, and so we needed to present it to this court. Obviously, if this court reinstates attorneys Baldwin and Rosie and orders the judge off the case, that if we proceed forward with the trial, that they can refile that with the senior judge who would take over the case. But the relief that Mr. Allen wants is he wants attorneys Baldwin and Rosie on the case, and he wanted a speedy trial. And in order to show that that's an intimate part of the trial tactics and decisions that were going on, was to present that to the court and make sure that this court had an opportunity to rule on it if it wanted to do so.
Does your argument depend on our having found that the trial court's underlying findings of gross negligence and incompetence were wrong?
No.
Well, if she's right about those findings, why isn't the relief that she ordered appropriate?
First, Justice Slaughter, she's not right about those findings. Second, there isn't a record to even substantiate those findings. But third, those issues don't involve.
If there's not a record, maybe then the findings aren't proper. But if the findings are correct, why doesn't what she did follow from those findings?
Because the client has the autonomy to choose the direction of his representation. And if he is aware that there may have been some sort of violation, or the judge feels that there's a violation, he is allowed to waive that concern and to proceed forward with the lawyers that he has developed a relationship.
Waive any, for example, she's concerned, at least as I understood the record, she's concerned that with these counsel proceeding on his behalf, if they go to trial, he may well have built-in reversible error because his counsel are ineffective, constitutionally ineffective. And if you're talking about a waiver of rights, are you suggesting that your client would waive?
That assumes that the judge did a proper decision. That's an assumption you can't have unless the records are showing it and a hearing accompanies it. You don't have that because she did not do it, in my opinion. But these are the Supreme Court judges. Who knows where they're going to go? And remember, Judge Gould was appointed this case from upstairs. So he's fighting an uphill battle.
Whatever Strickland violation might occur, were he to proceed to trial with these lawyers?
Judge, that's almost essentially what happened with regards to the disclosure of the Westerman materials. He filed with the judges. I'm aware of that. I know what's happening.
I'm just asking you to tell us on the record whether that's something you're asserting on your client's behalf. If we grant the relief you want, there will be no Strickland claim that can be asserted because you're waiving it.
I think on the if the judge was to build appropriate record, that can happen. The judge, that's what happens in all conflict of interest cases, and that's what happens under this court's case law. You bring the defendant into chambers, you say, listen, in Lada, he's representing the wife, he's representing you, or excuse me, he's representing your husband, ma'am, and he's representing you. Do you fully understand that by proceeding forward, that could cause some problems for you? And he may not have fully disclosed those to you because his interests, his loyalties are divided.
Well, if I hear what you're saying, you're invoking your client's right to counsel of choice, but you're disclaiming your client's right to competent counsel if and when he goes to trial.
Disclaiming, no.
You're waiving your client's willingness or right to invoke a Strickland argument on collateral review.
The client can knowingly and voluntarily waive conflicts of interest, and he can waive certain issues for collateral review. Absolutely. But none of that happened here because the judge didn't hold a hearing. The judge didn't hold a hearing and say, listen, I feel like this pretrial publicity somehow a year ago is going to contaminate your trial.
Counsel, we're not talking about waiving conflicts of interest. We're talking about waiving ineffectiveness.
Yeah. None of these things that the judge is citing have anything to do with ineffectiveness of trial counsel at trial. Ineffectiveness is not coextensive with ethical violations.
She found his representation was grossly negligent and incompetent.
She said
Prove
you're grossly negligent and incompetent.
lawyers,
I don't know if it was about trial representation at all. And in the arguments that she advances in the brief regarding what she says is grossly negligent and incompetent have nothing to do with whether a fair trial is going to happen here. And if there was a hearing where these matters were discussed and fully vetted, that either the client could waive any Strickland issue as to those issues, or the issues would be proven that the judge there's no foundation for the concerns that she's had.
Mr. Lehman,
Yes, Judge.
that's really what I'm struggling with. Our original jurisdiction is very limited. And so if we were to agree with you on the substantive arguments that you've made, why is it that the regular appellate process is wholly inadequate?
Justice Goff, interlocutory review and direct review are impossible and don't get us anywhere near the relief that my client's entitled to. My client was entitled to a jury trial today. My client's entitled to a jury trial with effective lawyers that he spent a year and 3 months developing a well thought out strategy of third-party guilt and a speedy trial to catch that prosecutor on their back foot. And it was blown out of the water from a judge who exceeded her authority.
Very good point, Erin Olivia. His new lawyers seems to agree with the chosen path. What is Judge Gould going to do? Recuse them as well because she doesn't like it? She handpicked them. One of them is a Facebook friend of hers, and they still move on with the same as the old lawyer team. What's happened now is, since she handpicked these two new lawyers, instead of having a trial in March, they're having a trial in October. And looking at Mr. Allen's physical health and mental health, I'm not sure he will survive that long.
And so we would have began that interlocutory review process by putting a motion in front of the judge, asking her to certify an order that we weren't even sure what her order was, but she wouldn't give us the transcript until we came to this court and insisted that she get it to us so we could figure out what the scope of what happened was. So she would have had 30 days to rule on that interlocutory request. Meanwhile, Ms. Winicky and I got this entire case briefed on an original action to this court in less than 30 days with amicus filings on all parties, and that was even with the judge asking for an extension of time. This gentleman had attorneys Balden and Rosie, who he'd been working with for over a year to develop and get ready to catch that prosecutor on their back foot with a well-developed third-party guilt strategy that was to be going now.
Mr. Lehman, we would have a full record if they hadn't agreed to withdraw, correct? It would have gone to hearing?
I don't think they would have had a full record even then, Judge. The judge was saying that there was a coercive action of the judge. I'm going to go out there and I'm going to say these things. And Mr. Rosie presses at her. Well, what's that proceeding going to be? And the culmination of it is, that the judge says, the culmination is you're removed. So the record, I don't know, would have been any better. And in fact, it would have harmed Mr. Allen even more because it would have put on the public record the judge's personal bias towards the strategy that he had developed, which is a strategy of these two gentlemen.
That's one of the things you have to prove with regard to the request to recuse.
Well, we believe, Your
Because you're
Honor,
saying
Amicus brief is a friend of the court is sending in a letter to either oppose or reaffirm the strategy or how important it is for the judges to take up this and how to rule. So, no, it's not the trial. This is an appeal to the Indiana Supreme Court. It's a hearing about reinstating Mr. Allen's original lawyers. Exactly. The judge ordered things to be deleted, not stricken, deleted from the record. I hope he will have the time to bring this up. He has very limited time to do his argument.
there's not enough for this, but there is enough for that. There's not enough information with regard to the negligence and incompetence, but there is enough with regard to personal bias.
Correct, Your Honor. I do think I don't think
Got a
those positions are inconsistent. That there is no evidence of incompetence, certainly no evidence of trial incompetence, which is what the Sixth
My
Amendment
concern is getting
requires.
this case back on track. All
Yes.
right. So your argument is that you have a constitutional right to counsel of your choice in this circumstance, and you acknowledge there are some circumstances that you do not. And if this case would go to trial, if there was a conviction, it's structural error and it'd be reversed and everybody would have to go through this again, correct?
Yes. Judge, but I do want to clarify that this is more than just the choice of counsel case. Like, this is an interference of counsel. This is the right to counsel itself, because the right to counsel is meaningless. If a judge can say, stop all work, I know you've got a relationship going on, stop it all till you come to my chambers, and then says, you're off the case, whether we go into the courtroom or you stay in here, you're off the case.
A lot of events in this case that led up to that hearing, correct? With regard to sending information on a case to another criminal defendant, with regard to, well, there's a lot. I don't need to go through it in both your briefs. So there's a lot of questionable things that have occurred up to this point with regard to the release of discovery or letting third parties have access to discovery.
Have access? He stole it from the office. He stole it and then released it. None of the lawyers released to the public. If you go by that standard, the prosecution released more about this case than the defense did. Now, the defense put in their big Frank's motion, 137 pages, where they put in, we believe this is a crime done by this Odinist cult. And they pointed everything out. Now, that might have been too much, but that has not been ruled on because the judge did not put it on record. And as you in the chat reminded me, she ordered the deletion of documents.
Is there no line that a judge, let's say that everything was turned over and counsel didn't show up for hearings. Is there ever a line that a trial court judge has to say, listen, I know this is your court, at this point, a court-appointed counsel. I do not think you're going to get a fair trial, and you're going to set yourself up on the flip side for reversal, just like I talked about the structural error being grounds for reversal the other way. You're going to come in on a Strickland ineffective assistance of counsel and say, my attorneys were not effective. I mean, I lost, and this is because my attorneys did X, Y, and Z.
Yeah, the not showing up for hearing is a unique situation because one is the lawyer's not being a lawyer at that point. They're not
Filing briefs, not meeting deadlines, not submitting a brief of AI that doesn't make any sense.
So, Judge, if a judge is exhausting other remedies short of disqualification, extreme misconduct will eventually fall into one of our other categories. That is, the client will object to the continued representation, that the lawyer will be removed from the case, the lawyer will eventually himself pull out of the case, or a conflict of interest will develop. And we see that in some of the other cases across the country. And so, like, if a lawyer in one case was obstructing justice, he was literally going behind the scenes, talking to co-defendants who were represented, trying to manipulate their testimony. The judge at that point just proceeds forward with the law on conflict of interest. It says, calls forward those witnesses, said, did this lawyer try and obstruct justice? Did he try and commit a crime? And then at this point, a conflict of interest occurs, because then the lawyer can't advise the defendant to take a plea because for fear he might himself be more criminally culpable.
But you believe that all conflicts are waivable. Am I understanding your position right?
I think that our rules is that an actual conflict of interest is unwaivable when you sue one party versus the other. And shockingly, that seems to have happened in one of the cases in Indiana. But other conflicts are waivable conflicts, and other than that one rare exception of.
And I'm still a little confused with the exchange with Justice Slaughter about the waiver. So let me ask it this way. If we grant you the relief you're requesting, we reinstate counsel, and Mr. Allen's convicted, can he pursue through PCR, post-conviction relief proceedings, a claim that his counsel were ineffective for the very same reasons that the trial judge here found?
So the trial judge here found that he can't, it depends on what record the court would build regarding those, but no, I'm going to change that, Justin. No, because these issues have nothing to do with effective representation at trial. So I don't think he could pursue them on those grounds. But so I don't see how these three violations, the inadvertent disclosure of pretrial discovery, that the press release over a year ago in direct response to press that the government was putting out, I don't see how those issues affect his trial. So I don't think he gets a post-conviction relief through that, because those issues don't affect trial strategy.
But you're saying he would lose on the merits. You're not willing to concede that it would be waiver. And it seems odd that he could have it both ways, that he can say, you can never remove my counsel over my objection. I object, but then still have available to him the argument later that, well, even though I objected, it was still ineffective.
If the judge exhausts, I think the judge can take care of that. The judge can call, say, let's have a hearing regarding that pretrial publicity and somehow establish that that might be affecting his trial, and that fully and fairly advise him that that's a repercussion. But when he's fully and fairly advised of that, the repercussions of that judge's subjective belief that there was somehow some sort of ethical violation there, I think that he would be waiving it. So,
Well,
yes.
Counsel, are you arguing that the record doesn't support a finding of ineffectiveness by the trial judge? Or are you saying if the judge finds it, she still can't remove him?
Both. This record does not support ineffective assistance of counsel.
But even if it did,
No, sorry. The reasons that she advances aren't reasons to find a lawyer ineffective. Now, if this court was to say those are reasons that that would constitute ineffective assistance of counsel for a Sixth Amendment violation. So if we were to get to that point and he was fully and fairly advised of the potential repercussions of those violations on his trial strategy, then you could have a waiver issue. But the reasons that she cites for doing what she did have nothing to do with trial. But let's assume for a moment that she cited a reason that there's an intimate relationship going on. And she pulls them in, and goes into the chambers and says, listen, I understand that there's an intimate relationship occurring between the defendant and you. Do you understand that's a conflict of interest? That's a violation of the ethical rules, that there's a disciplinary proceeding that I'm going to be referring for him. Do you want to go forward with this representation? And the client says, yes. I think you've got a waiver of ineffective assistance of counsel on those grounds, but I don't think that the judge is absolutely precluded from injecting herself and saying, well, that in that case would be a conflict of interest. So we're struggling to find a situation where there's an ethical violation that affects the outcome of trial, where there's a situation where the defendant says, I want to go forward, I've been fully and fairly advised of it, and the judge somehow has a role, absent a conflict of interest, injecting herself into that. And I do think that you can waive you can waive an ineffective assistance of counsel claim. That's well-established case law. It's just none of these things the judge cite have anything to do with ineffective assistance of counsel. These are purported ethical violations, and not every ethical violation necessarily, even if it was established, has anything to do with trial strategy and whether a defendant receives a fair trial. And these are examples. These are good examples of that. In that the inadvertent disclosure of pretrial discovery the alleged violations here would have nothing to do with the trial strategy that attorneys Baldwin and Rosie developed with him, and would have no impact on that case.
Mr. Lehman, let me just sort of ask with respect to the line of questioning, if we were to agree with you and find that there was inadequate reason, at least on the record, to allow for the removal or the refusal for counsel to reappear, nothing would stop the trial court from making a more complete record and going through a different process if in fact it believed that there were sufficient reasons to remove them. They just weren't adequately reflected in the record.
Judge, I think a court has broad discretion on how it conducts proceedings in the courtroom, but none of the reasons that she cites in her brief would allow would even if found would substantiate the removal.
But if the court were nonetheless worried about the finality, the eventual finality of the proceedings, and wanted to nip a problem in the bud, is there anything that would stop her from conducting a proceeding on remand or similar to prevent that from happening?
I think if
What would happen if they were reinstated as the lawyers and Judge Gould produced a hearing where she this and this and this and this? Then you have a record of it and her reasoning. Then you can cite the correct case law and appeal that again. But what we are having here is, in my personal opinion, is Judge Gould is so biased. I don't know what's going on with her, but her bias is so clear to me that she should have recused herself before this hearing. Just hands up, yeah. And remember, she was hospitalized to the degree that she removed herself from all other cases but this. Why? If you're that sick, why do you cling on to this case this much? Why?
There's a concern, say, for example, the pretrial publicity, the press release. If you say, listen, I think, because the violation says it has to affect the fair trial. So, okay, you're going to have a hearing. The judge could have a hearing. Let's provide proof or get some sort of sense as to how this has affected the jury pool or what prejudiced the jury pool. I assume the judge could conduct some sort of proceedings to investigate that. But if the client is fully and fairly aware of those proceedings and still wants to proceed forward with these clients, then the judge has an absolute duty to accept or to act on his wishes.
Counsel,
Mr. Lehman, is it your belief that if we deny the extraordinary request that you've sought today, and if the case goes back to trial with a different set of lawyers that this defendant just does not want, that there is built into that record
Structural error.
at least fundamental error, maybe structural error that's reversible?
Trials for sure. It's a practice only trial, Judge. I think, and that's why we came here as fast as we could, because if we do not get something done now, the victims are going to be hurt, the public's going to be hurt, the entire Indiana judiciary is going to be harmed because this trial's been pushed off till October. And when the judge said it in October of 2024, one of the lawyers, I believe, even represented, he didn't think they were going to get that date either. Everybody's hurt, and we're going to delay things.
And you think the Gonzalez-Lopez precedent of the U.S. Supreme Court would dictate that outcome?
I think it's structural error, yes. So, and that this trial is going to be for practice only, and we have built-in error, and the only way we can fix it and address the speedy trial problem, because that was an intimate part of the trial strategy, is to get attorneys Baldwin and Rosie back on the case and get this case set for trial in a time frame that's as fast as our law allows, which is 70 days. And that's what the relief we're requesting. Thank you very much.
Thank you, counsel. We'll hear from you again on rebuttal. Mr. Gutwein.
Mr. Gutwein, sit down and shut up, but he won't.
Chief Justice Rush, and may it please the court, I am Matthew Gutwein, representing Respondent, the Honorable Francis Gull. This court should deny the petition for 3 reasons. First, the trial court's decision to remove Mr. Allen's counsel was an exercise of discretion, and this court has uniformly held that a writ of mandamus will not lie in matters that rest with the trial court's discretion. Second, Mr. Allen's remedies on appeal are not wholly inadequate. The United States Supreme Court and Indiana's appellate courts have regularly resolved Sixth Amendment claims, such as those that Mr. Allen raises here, to the ordinary appellate process. And third, on the merits, in removing Mr. Allen's counsel, the trial court did not abuse the court's discretion. The trial court has significant latitude to prophylactically prevent a violation of Mr. Allen's constitutional.
Here's the thing, Matt Gutwein. I know you're doing the job. I know you're doing your job. But if we allow judges to remove counsel on these weak grounds, allowing judges to delete records, allowing to remove people by threats, what's left of the judicial system if we allow that? How easy would it be to get a judge, either by finance, by threats, by whatever? Hey, we want this to happen. How easy would it be? In my opinion, this is a clear violation of Mr. Allen's rights. And his rights are eons more important than Judge Gould's discretions, in my opinion.
Right to effective assistance of counsel.
Counsel, is that really what's going on here? We don't have a great record before us on which to make
you have a false record. In
reading what we have, I'm left with the impression that it's quite possible that 2 different concepts, ineffectiveness and insubordination, are being conflated here. There seems to be a great deal of concern by the judge that these lawyers were flouting her gag rule, and that they were insubordinate. But where's the evidence in the record that they are constitutionally ineffective? I mean, the order seems couched in that language that we're trying to
Good
protect
question.
the defendant from his own lawyers. But it's hard to look at this record and not get the impression that perhaps rightfully so, the judge was exasperated with their conduct. But these are two different things, aren't they? Insubordination and ineffectiveness.
Under United States Supreme Court decision in Wheat, the trial court, in exercising her discretion to remove counsel, does not need to find constitutionally defective counsel. It does not need to require ineffective counsel. Rather, as in Wheat, there just needs to be the possibility of ineffective assistance
But I'm really
of counsel.
struggling with that. Butting that up against the Sixth Amendment constitutional right to counsel, and particularly when they filed the second petition of filing as private counsel of their choice, that's structural error. And I agree, it is. Okay, you can shake your head, but I'm reading the Justice Scalia and taking him for his word on what that is. And how do we get this case back on? So we have that hearing. You have issues with regard to, well, you gave a press release. Well, the gag order was after the press release. You've got, well, we don't like, what you filed in, I think it was in June, with regard to conditions in prison. Well, most of those were wrong, but that means some of them were right. We have in the record now, because we can take notice, there's a new motion to transfer Mr. Allen filed by his current attorneys. So we don't have a hearing. We don't have findings. You've got a constitutional right to counsel. And he's choosing this counsel. You have a constitutional right to say, I don't want an attorney, correct?
Under Wheat as well as Lotta, this court's precedent, he does have a constitutional right to select counsel, but that constitutional right is highly limited. And that
Here's the thing. Not only did she remove them as court-appointed counsel, then they came back and say, we will represent him pro bono, and she refused them. That's not included in your argument.
right may be outweighed by
But
any number of interests.
But counsel, you're a very, and I'm quoting Chief Justice Shepard in the Knox case saying, a judge has a very limited right to tell someone who their attorney can be. They just decided not to go the parameters there because there was an agreement to withdraw.
Wheat says the opposite, Your Honor. Under Wheat, the trial court's discretion, when faced with the balance between, on the one hand, counsel's right to select counsel, and on the other hand, counsel's right to effective assistance of counsel, what Wheat says is the trial court is to be given substantial latitude, is to be given wide latitude. What Wheat says is that decision is best left for the intuition and judgment based upon the experience of counsel in weighing those competing rights. Wheat says, in a highly deferential standard, that the issue of whether trial counsel should be removed must be primarily resting.
And I don't read Wheat, and I looked at Wheat several times as strong as what you're doing. And I think what you're doing is you're butting right up against a constitutional protection, and you're doing it at your peril, and this court would do it at this peril with regard to a case possibly having to be tried twice and having everybody going through that again.
That exists either way, right? In other words, as this court has already identified, if they don't.
Oh, screw you. That right exists anyway. There's a difference between structural error and a normal appeal. I mean, it's not even in the same. It's not even in the same. It's not even in the same ballpark. It's not even the same sport. It's a parallel universe in difference, in my opinion.
If the trial court, if Judge Gull does not remove counsel, then counsel has the possibility of raising an ineffective assistance claim.
But isn't that a really good reason for us to just go ahead and address the merits? I mean, I'm a little confused why the respondents don't want us to address the merits. I mean, I realize you think there was no mistake, so why not ask us to just say that? And you're certainly right that we have plenty of cases saying in original actions, we don't review discretionary issues, especially not issues of first impression. But I think I found at least 4 cases where we went ahead and did exactly that. We've looked at attorney disqualification issues, including issues of first impression. So why isn't it in your client's interest to just get an answer from our court one way or the other, whether this was error?
Well, I do think that it would undo enormous amounts of procedural law on original actions. I mean, this case has so many procedural hurdles that Mr. Allen cannot scale based upon the procedural requirements. And I don't see how this court could exercise a limiting principle that somehow it's perfectly fine to grant the writ when this is a matter of discretion. The court doesn't grant writs for matter of discretion. There's a remedy on appeal. The court doesn't grant writs for remedies on appeal. They never specifically even ask for this relief in the trial court. The court doesn't grant writs. So I think you would be doing structural damage to your original action jurisprudence and frankly then open up the floodgates, because these kinds of pretrial claims of constitutional violation are extremely normal. They are extremely rare. And if this court wants to get in the business of addressing the merits every time a criminal defendant raises a pretrial constitutional violation, you will be flooded with these kinds of actions.
So
Well,
your
tell us why you
solution,
think that Mr. Lehman's argument that no meaningful appellate right exists is just wrong from your perspective.
Well, that is absolutely wrong. And Hannah reflects that. Hannah is an interlocutory appeal on a claim for a violation of the right to select counsel. And on that interlocutory appeal, the Indiana Court of Appeals found there to be a violation and restored counsel. There can't be any serious question that these kinds of claims for Sixth Amendment violations, right to select counsel, are resolved on the ordinary appeal process. In fact, every single United States Supreme Court case to address the issue of the right to select counsel made it to the United States Supreme Court through the ordinary appellate process. And the Supreme Court had never so much as even hinted that the relief on appeal is somehow inadequate for a Sixth Amendment
And just so
violation.
I'm clear, what you're talking about in the ordinary course would be a final judgment. He goes to trial with different counsel, he's convicted, and then you go up and appeal in the ordinary course?
No, not necessarily. I mean, here, there are interlocutory appeals, there are emergency interlocutory appeals, there are appeals after final judgment, there's appeals on PCR. And we have examples of all those cases. The absolute fact is that the ordinary appellate process offers a wide array of avenues for Mr. Allen to seek relief for his constitutional violation, and he has availed himself of none of those avenues.
What about our 1982 precedent? So State versus Tippecanoe County. The shoe was on the other foot. It was the prosecutor's office that was disqualified, and the prosecutor sought a writ in our court. Now, we denied the writ, but we said that it was an issue of first impression. We reached the merits, and we gave the state the answer that it wanted through an original action.
Let me answer that in 2 ways. First of all, you've already identified this court denied the writ in that case. And second, there is no discretion for a prosecutor who has a conflict to prosecute a case. And in that case, the trial court had no discretion, had an absolute obligation to remove a prosecutor who has a conflict. That is not the case here under the United States Supreme Court's jurisprudence in Wheat.
Here is what he's not telling everybody, is that her discretion must be based on actual evidence, and without a hearing there's no evidence to show. Now the claim is in this made shift here in Chambers meeting, they recused themselves, which they were more or less forced to do. At least one of them said outright, then I will remove myself because I don't want to subject my client for a hearing where you already made up your mind. And the other one said, I will send it in later. Here's the thing. He never said he would actually do it. He was buying time. So I don't believe this, because in my opinion, Judge Gould's reasoning for this are lies. She lied to the Supreme Court, in my opinion, in her briefs to the court. That's my personal opinion. You can take it as you want. Thank you, Haley Wolf. Thank you so much for your $2 super chat. Yeah, and she ordered records deleted. That would, in my opinion, when this is brought up to the Supreme Court, they only need to hear that she deleted records. And they would say, okay, you're out. Bye-bye. Have a nice time. We will send it to the Indiana State Bar, in my opinion.
Decision to remove counsel based upon the possibility, based upon the potential for there to be.
But it has to be done, there's a way that you do it, and it does not appear this was done the proper way. You're supposed to have a hearing. The court did it sua sponte, which means on their own motion. There was a hearing in chambers. So did she exceed her authority by the manner that she presented them back in chambers, saying, you're either out or I'm going to publicly out you?
Well, there's certainly no U.S. Supreme Court case law or Indiana case law that says there has to be a certain amount of
So
procedure.
there's no process involved at all for taking a judge, no hearing, no, I have the suspicion that this is going on. I think you're incompetent and you're out.
Well, the trial judge was prepared to have a hearing here. A hearing was.
Oh, bullshit. She was not preparing a hearing. Here's the thing. What she was preparing, because this is the first time she allowed the court to be live streamed. That specific hearing. In my opinion, her entire goal with that hearing was to humiliate the lawyers. With having cameras there, microphones there. See, what she did was bringing in the lawyers, only the lawyers, not Mr. Richard Allen. And as you know, the defendant has an absolute right to be there with his lawyers, and she denied him that right.
Scheduled. Counsel had notice of a hearing. The prosecutor was there ready to present witnesses. And the counsel in this case made their own strategic decision to withdraw rather than go out in open court and have a hearing. And that was their choice. And they made that choice, I'm sure.
Having read the transcript, was it a full and free choice?
Well, these are very experienced lawyers. These are highly competent lawyers in other contexts. And
oh, now he has to argue they are competent and highly skilled enough for that. But according to Judge Gould, they were so incompetent they had to be removed. Now you're speaking out of both sides of your mouth again.
they had notice that the judge was considering disqualifying them. They had notice on October 10th when the judge told them that she was considering disqualifying them. They were leaning in that direction. And between October 10th and October 19th, an awfully lot of lawyering occurred. On the 11th, Mr. Rosie got together with their client and drafted a letter. On the 12th, Mr. Rosie filed a highly detailed letter with the court offering his defense and asking not to be disqualified. Sometime before the 19th, Mr. Baldwin hired outside counsel. On the 19th, outside counsel filed a brief. They had oral argument. There were 9 days of an awfully lot of lawyering that occurred in that period. And at the end of that, what both counsel elected to do was state their intent to withdraw. And Mr. Rosie said, I've got a life outside of this case. I've got a life outside of this courtroom. I have a family. I have a law practice, and I'm going to withdraw. And that is his choice. That is his decision to do that. But if they had wanted, they could have filed for a continuance. They didn't do that. They could have gone out and had a hearing. And
That's so much bullshit. If they had filed for a continuance, she would have denied it. It was clear how she set it up, with cameras in the courtroom and everything set up so she could humiliate them as lawyers and practically ruin his entire case and ruin the choice of defense of pointing at third party, somebody else did it. She would have ruined that to the public.
Presented evidence. They didn't do that either. What they
Would
did
any
was
of those
withdraw.
actions,
Again, if you're here and you are certain Mr. Allen is guilty, I understand. There's a lot of evidence that speaks to it. Has nothing to do with it. It is, if we don't provide rights to the worst of them, we will not have the rights for the people we actually believe are innocent. It's the process that's important, not Mr. Allen, not Judge Gould. It's the process on how a defendant should be treated in a justice system. So take my opinion as just an opinion. It's the process. Yes, he is innocent unless proven guilty in a court of law. And in my opinion, my personal opinion, the judge is trying this case in the public opinion and was going to do it by this hearing to ruin his chance of a proper defense.
have been non-futile? I mean, I thought the judge made clear that her mind was made up. She had prepared a script. She'd already made the decision. If they wanted a hearing, they could get it, but there was no opportunity to persuade her. Did I misunderstand?
We'll never know, right? Because there wasn't a hearing, because counsel elected to withdraw.
You do know, because she said then at the hearing on the 31st, what's changed. So, which means,
Well, we
We
won't know
do
what
know
would have
that.
happened at a hearing that never happened, but you're right. I mean, I certainly acknowledge that she probably wouldn't have changed her mind.
Counsel, I
Exactly.
appreciate you
This is a dangerous,
looking out
dangerous
for
precedent.
our
If
original
they go
action
against
jurisprudence
Allen.
and our potential future caseload, but as long as we're here, what can you tell me, what can you point to in the record that supports a finding that these lawyers were ineffective to the point where they needed to be removed to protect the rights of Mr. Allen?
Again, under Wheat, there doesn't have to be a finding that they were actually ineffective. What there has to be a finding of, and this is under Wheat, that there is the potential to be ineffective. And here, it is not within the norms of the profession to negligently and repeatedly allow the unauthorized disclosure of highly confidential material
Can you
and
help me
attorney
understand?
work product.
Can you help me understand how that hurt Mr. Allen's defense?
Well, believe Mr. Rosie. Mr. Rosie himself said the likelihood of public backlash is significant, and this leak serves no legitimate public purpose. The reality here, as we all know, is that we already.
Oh, you complete asshole. That was not in the context of the Frank's motion. That was in the context of material being stolen from their office, from one of the lawyer's office. Stolen. Oh. Taking quotes about one thing and applying it to the other. That's so disingenuous.
have a polluted jury pool because of the inordinate pretrial publicity that this case has garnered. And the further disclosure of highly confidential inflammatory material further pollutes that jury pool, making it that much greater to have a fair trial for me.
The crime scene photos was not a disclosure. This is so disingenuous. Those photos were stolen from the office.
Mr. Allen. And the trial court is rightly and appropriately able to exercise under Wheat, and I quote, intuition and judgment based upon experience to find that if counsel is capable in the pretrial stages of making this many mistakes, what manner and magnitude during trial is counsel
I keep
capable of
getting
making?
back to it, and I understand what you're saying, but I keep getting back to, if a criminal defendant has a constitutional right to say, I'm going to be my own attorney, well, that's fraught with more than just
Yeah.
what we're talking about here. He wants these attorneys. And so we're spinning and spinning and spinning on this, saying delay and this, but he wants these attorneys. There's not been these findings with regard to incompetence. There's a lot of words out there, but let him have his attorney. Get this case back. Let him have his attorneys. He wants to privately hire them. I'm really struggling with why he can't make that decision that that's in his best interest and get this case moving again.
Yes.
Let me answer that in two ways, Your Honor. First, again, in Wheat, the accused in Wheat, Mr. Wheat, knowingly and intelligently waived the conflict in that case. And there was only a potential conflict. Wheat
It was
waived
a
that
major
conflict.
conspiracy with lots of different people playing, in the Wheat case.
Wheat
I don't see
himself,
Wheat as tucked as neatly as you find Wheat. So
Wheat
go
him-
outside Wheat and give me something else.
well, but again, Wheat himself,
Lawyer, when she tells you to go outside of Wheat and give her something else, you do it. Here's the thing, he can't. There is no other case law he can cite.
claimed that this conflict was highly remote, highly unlikely to occur. Very small chance that the conflict will ever occur. And he waived the conflict, and yet the trial court found, based upon the court's intuition and judgment, based
But
on...
where can you point to me saying, with regard to saying somebody is incompetent or negligent? We have a string of cases. So these conflict cases have come up before with disqualification. Where are we on this?
Well, again, it is certainly
Yes,
not consistent with the
he's
norms
not.
of the profession
So
to negligently and repeatedly allow the unauthorized disclosure of highly confidential material that will pollute the jury pool. And here we already have a jury pool.
I can't be anything else.
Does that rule apply both ways? Because one of the things defense counsel
The jury pollution was there long before, when the prosecution handed out Mr. Allen's face together with the sketch that mildly looked like him. Here's the thing, Mr. Allen lived in that community for years, and not one took a look at the sketch and Mr. Allen said, "Oh, he looks like that." There was a voice recording that was out there. Not one listened to that and then said, "Hey, wait a minute, that sounds like Mr. Allen." Not one. But the prosecution chose to put the video of the man on the bridge together with the voice recording. Here's the thing. Those two were separate on the phone. But the prosecution put that guy on the bridge with the voice next to Mr. Allen. How is that not poisoning the jury pool? And yeah, I can't be anything else. In my normal line of work, I do labor law. I have to be so stoic all the time. So this is so liberating for me. Let's continue.
said in their letter to the court was that they believed that the state had allowed the dissemination of information regarding the crime scene. So can a judge disqualify the prosecutors too?
Well, again, the judge certainly could disqualify the prosecutor. We don't have any evidence in the record. We have Mr. Allen's counsels asserting that. There's never been a hearing on that. There's never been a finding on that.
I'm just
Yeah, but that's just the point. That's double standard. That's the point. Why is only the defense? And this is general all over the playing field in most states, most trials I've ever covered. Why is never the prosecution punished when they do stuff like this?
trying to understand the scope of the rule and how sharp of a double-edged sword that this might be, that any leak of crime scene photos or anything like that can lead to the disqualification of counsel on either side, I think is your position.
Well, Your Honor, our position is under U.S. Supreme Court precedent as well as this state's precedent, this court's precedent, the trial court is vested with discretion. And even Wheat said that faced with the same facts, one court might find discretion.
The judge just told you, give us something else than wheat. The wheat case. And he can't, because there is no other case he can cite. And that's what they're after. Give us something else. I'm hoping this is indicative of them leaning towards Mr. Allen's rights before the judge's discretion. I'm really hoping, but you never know. You never know.
Qualification appropriate, another court might find it not appropriate. But because two courts could reach exact opposite decisions in matters that rest with discretion, doesn't make one right and one wrong. So I'm not suggesting, nor is Judge Gull suggesting, that there's an absolute rule here that every time there's an unauthorized disclosure, that gets into the discretion of the trial court.
You would agree the practical effect of the position you're advocating today will cause the significant delays in this case going to trial?
Yes, I agree with that.
Does that have to be a factor in the consideration when exercising discretion?
It doesn't have to be a factor. It certainly can be a factor, right? The trial court, in exercising its discretion, is allowed to consider the totality of circumstances. And again, we went out of its way to say this decision can be based upon intuition and judgment, based upon experience, which requires less detailed findings.
Told you to stop citing
And
wheat.
it's a highly deferential standard.
Mr. Gutwein, I guess more to the issue before us, when we're deciding whether or not the regular appellate process is wholly inadequate, how should we weigh the delay, especially when it's been asserted that Mr. Allen wants to exercise his speedy trial right?
Well, again, Justice Goff, as you already recognized, counsel never filed the necessary paperwork.
True, he did. They didn't. They didn't file it because they were waiting for discovery. They were waiting for decisions that never came. And all of a sudden they were out. Filing the speedy trial motion is a tactic in itself. You can do it as early as you want or very late. You can have everything prepared. So the very preparation of this should be accounted for. But they never filed it. Then again, Judge Gould never had the hearing. Then again, Judge Gould deleted documents from the docket. Yeah, I believe that judge's discretion, yes, there is. Does a judge's discretion eliminate the Sixth Amendment? I don't think so. Unless they rule it, and then we have an extremely dangerous precedent in the state of Indiana.
To exercise that trial. So that issue is, I would say, not appropriate to seek relief because it doesn't satisfy the basic threshold condition precedent for seeking relief here.
Whether we give relief through an original action or we're concerned that there should have been more process afforded in this issue, a more full process with respect to the issue of removal. What possible harm could there be if we were to go do it the right way? I mean, if we're concerned about the eventual finality of these proceedings, everyone having to go through and do it twice, whether we reinstate counsel, we remand with current counsel and say you need to go through this process, wouldn't that save time in the long run?
Well, let me, perhaps, we don't know, but let me offer
Wouldn't that
this.
protect everyone's interest in finality in the long run?
We really don't know
That's a
what
bad
Mr.
answer.
Allen wants.
Yes, you do.
And it
Now
was
you are
not
lying to
necessary
the
for
court.
the trial court to hold a hearing to judge his wants because she was removing counsel. But if this court were to consider reinstating counsel, then the trial court would absolutely be required to probe his interest and make sure that he understood that counsel in this case had engaged in conduct that was.
That is something she denied Mr. Allen in this makeshift hearing in her chambers. She didn't want Mr. Allen in there, which is in direct violation of his constitutional rights, in my opinion.
Detrimental to his interest, as counsel himself has already acknowledged it, and then see if he has a knowing and intelligent interest in having counsel continue that clearly, on this record, has engaged in conduct that's detrimental to his defense. I have exceeded my time, and so I will yield the remainder of my time to my good friend, Ms. Sanchez.
Thank you,
Your
Mr.
Honors.
Gutwein. Ms. Sanchez.
They are allowing 2 people from the state to argue? Why? This is weird. Well, I don't know the exact rules and regulations of the Indiana Supreme Court.
May it please the court. There's nothing clear or absolute about this case, the record, the proceedings that led us here today, the legal issues before the court, or the nature of the rights that Mr. Allen's counsel today seeks to vindicate. There are means through the trial court and the appellate process to untangle complicated questions.
Yeah, these are those. She's counsel for Respondent. Respondent here is Judge Gould.
This court has repeatedly stated that those are the methods that are far more well suited to such complex issues. The appellate process, for example, would allow a full record in the criminal case, which we do not have here. It would make the parties to the underlying action the actual parties in this case, unlike here where the Attorney General's office is in the nature of something like an amicus, wherein the party of interest is the court, forced to act as advocate in defense of itself. What
would be the harm if because of the necessary delays in backing up and going back through again, reinstating counsel, and if the judge is correct, then that will weed itself out and there'll be a hearing and it'll be done a proper way in the trial court and then come back up?
The state shares the concerns, most especially the Attorney General's office, given our role in original actions, about this court's caseload and the increased use of that. But putting that aside, as Justice Bassett suggested, there are other concerns here. In this specific case, we agree that if any form of relief were to be given that included putting these attorneys back on, it would absolutely be necessary that further proceedings were had. On October 19th, when the judge warned the counsel of her intentions and her concerns, they chose to withdraw to avoid a hearing at which the state was prepared to present evidence that
One said in that hearing, one said, I will file it later to buy time. And both did it to not cause harm to their client. Because if that hearing was held and Judge Gould had gone through with her, in my opinion, intentions of completely humiliate the lawyers and the defendant, that would have probably destroyed any form of defense for Mr. Allen, in my opinion.
May well have been about an active investigation, evidence that may well be relevant to a full understanding of the conduct that is of concern to the judge.
Thank you.
Of course,
Thank you,
the
Online.
summary proceedings in chambers don't allow full challenge, full understanding and elucidation of the concerns. So a complete assessment of what is at issue here and the risks. The risk not only to Mr. Allen's representation at trial and his interest, but the entire risk to the process. Trial courts are not just tasked with protecting the defendant's right to effective counsel. They're tasked with protecting the entire proceedings and the fairness of the proceedings for everyone involved, for the integrity of the entire system, for the reliability of the
Which
truth-seeking
she
function, and
has
for the fact that everyone will
Do you
believe.
agree that with, under U.S. Supreme Court precedents, Gonzalez, if there's this mistake made at the front of this case with regard to a defendant's constitutional right to counsel of his choice, that you can go through this entire process and have to do it again if there's a conviction?
Their state is concerned that if you look at what happened on the October 31st, and that is a very ambiguous series of events there, if someone were to conclude that what happened there was in fact Mr. Allen, it's a personal right to choose your counsel, he was in fact exercising it, and that it was wrongfully denied to him, that would be structural error. It is a concern for the state that if those things were to be the way that record was. Now, what's happening that day is itself another unclear and ambiguous thing. Counsel comes and files these appearances. On the face of them, they both purport to be pro bono, but also reassert the resistance to the rejection of the prior waiver and the desire to be reinstated as public defenders, a contingent willingness to be pro bono counsel. Of course, the only knowledge we have of Mr. Allen is, or what he wants, what he knows, what he understands is, of course, secondhand. The choice of counsel is a unique aspect of the Sixth Amendment right. It's completely separate from the right to assistance of counsel, the effective representation, which protects the fair trial right. The choice is about your autonomy and independence. It's a personal exercise. And we need to know that Mr. Allen is in fact the person who was making that choice, that he was in fact competent to make it. There's been many consistent allegations about his mental state throughout the case. And then of course that he has the information he needs to make that as a knowing and intelligent exercise of a constitutional right under the circumstances, including the concerns about his counsel, the other options that he has available to him that he's choosing against, and so on. So, of course, none of that happened in this case.
Should we at least start with a presumption in favor of the continuity of counsel?
There is presumption, highly
The default
significant,
rule,
weighted.
something like it?
At the end, the desire of a defendant, the state agrees, to either retain his counsel that he's had is a factor a court has to consider and give weight to amongst all of the considerations at play when deciding how to balance all of the concerns for a fair trial, for his representation, to all of the other issues of efficient.
And then are you aware of any Indiana cases where attorneys have been disqualified on grounds similar to this?
No, Your Honor. In fact, there's a wide variety of cases around the country for various conduct that could be contumacious, violation of court orders, behavior during court proceedings, or ethical violations. The trick here is that we find few cases that involve multiple different types of allegations, which appear to be what the trial court is raising, a pattern of behavior. But again, it's not fully explained because of the abbreviated proceedings below.
Judge
I think
Gould,
it's reasonable when looking at if that is in fact what the...
and this is because Judge Gould actively sought to have incomplete records to cover her own ass. in hope that her decision and her discretion alone would make it that she could allow herself to violate Mr. Allen's Sixth Amendment rights.
Judge means, I think it would be reasonable for a trial court to have concerns greater about the prospective performance of counsel and the effect of their performance on the proceedings looking forward, if what the court was recognizing was a pattern of conduct that violated the rules, that tried the case in public, that did not follow court orders, et cetera, et cetera, et cetera. But where any one of those incidents in itself might not
But there's
sufficient.
no other case out there where a judge sua sponte on her own motion disqualified based on her finding, her belief in incompetency and gross negligence.
There are cases of disqualification based on the court's own motion, and even in.
But for these reasons, it could be conflict, it could be.
The wording the judge chose is unique in itself. Another point that would help with the larger record to explain exactly what the judge means, because of course we presume we're inferring from that choice of words and the particular thing cited by the judge what she meant by analogy to the use of
definitely
ethical rules, the ineffective assistance of counsel cases, and so forth. But it's not the typical language.
Just so I'm clear, you've acknowledged the risk of structural reversible error if this defendant proceeds to trial with the new counsel that are now representing him. Despite that, the state's going to double down and say, no relief today. Is that right?
No, we don't think it's a writ. There's no order. There's no absolute duty for anything to be ordered by this court. That said, the state does acknowledge that there are proceedings that can continue to happen. If Mr. Allen, in fact, is trying to exercise his rights, there just isn't prevented from doing so.
That's a very, very interesting choice of words. Let's go back and listen to that again.
Anything to be ordered by this court. That said, the state does acknowledge that there are proceedings that can continue to happen. If Mr. Allen, in fact, is trying to exercise his rights,
if Mr. Allen keeps exercising his rights. Let's listen to that again.
The state does acknowledge that there are proceedings that can continue to happen. If Mr. Allen, in fact, is trying to exercise his rights.
If Mr. Allen tries to exercise his rights. That's the opposition, in my opinion, from the Attorney General, from Mr. Gould's counsel, and from the state. Their opposition is Mr. Allen is trying to exercise his rights, and we are against it. It's appalling. I don't think she meant it to sound, she said the quiet part out loud then and there. Jesus Christ. That moment will be a short after this stream is done.
Just isn't prevented from doing so, even now.
Tell us more about that. What do you envision? If we go with the state's view and deny the writ today, what do you envision that might happen going forward that would minimize or eliminate the risk that we're talking about?
I see that my time's up.
Saved by the bell.
You can answer that.
Well, no one wants more proceedings. There's no barrier to the filing of further motions. There was no barrier prior to bringing the original action, whether it be motions to clarify the prior orders and then to seek appeal from that, whether it be a motion seeking to exercise and specifically exercise his right to choice of counsel, and then, if necessary, appeal that. there is nothing stopping further actions and motions in the trial court and proceedings in accordance with that. There never was.
Thank you, counsel. Mr. Lehman, rebuttal.
Am I at 7 minutes now? Is that, we don't know? All right, I'll go with it.
It should.
Justices, I would like to begin by correcting the record. The judge says that we don't know what Rick Allen's wishes were, and the Attorney General says nothing is clear. On October 11th, 2023, Rick Allen filed the following. Dear Judge Galt, please accept this letter as confirmation that I have communicated with my attorney, Bradley Rosie, regarding the circumstances regarding the leaking of sensitive information in this case. I am aware that the images of crime scene photos and other related documents were taken by a friend and former employee of Attorney Baldwin at Attorney Baldwin's office. I have discussed with Attorney Rosie the potential impact that the distribution of these documents could have on my defense. Attorney Rosie has also communicated with me that the prosecutor has requested that the attorney be disqualified from representing me in this case. I do not want this to happen. I want Mr. Baldwin and Mr. Rosie to continue to represent me until this case is resolved one way or the other.
We have that letter. We have that letter.
Yes, it's on page 221 of the record, Your Honor.
Counsel, what if we end up agreeing with Mr. Gutwein with respect to court-appointed counsel, but we end up agreeing with you with respect to volunteer counsel? I just want to make sure I understand the parameters of your requested relief. Are you only interested in having them reinstated as court-appointed counsel, or do you have an alternative request for their participation as pro bono counsel?
Oh, in my interpretation here, the court is giving an out for both parties, that Judge Gould had the right to her discretion to remove them as court-appointed counsel, but he can still retain them as private counsel pro bono. This will be interesting to hear.
Our obligation is the defendant. The defendant wants attorneys Rosie and Baldwin to represent him, and he could not be more clear despite what the other side has tried to represent. But to do a half measure is to credit the judge and the attorney general for allowing this to happen. And because Mr. Rosie and Baldwin were the ones who had an absolute duty to protect their clients' wishes, and they did everything they could to do that. To put them back in the case to say you're working for free or that Mr. Allen needs to pay you is to punish Mr. Allen and Mr. Rosie for doing what our ethical rules require them to do, which is to do zealous advocacy for your client. And those gentlemen, when faced with a real tough call, financial tough call, career tough call, they showed up on October 31st and said, listen, our client, he's been clear what he wants. And this is what we're willing to do in order to protect his rights. But to say that they need to go back in and work for free or that he needs to pay them is to miss what happened here, which is the judge had an absolute duty to act, and that is to accept his letter and his representation of what his expectations were, and that I want these gentlemen to see this case to its end. The Attorney General and the judge want to create ambiguity where none exists. We don't have records like this in other cases. This gentleman could not have been more clear on October 11th. There could not have been more clarity on October 19th. There could not have been more clarity on October 31st. And if your court looks at the new filings where he also is waiting for this court to rule because he's confused as to who his lawyers are, we have some clarity here. And to do anything short of putting them right back in where they were when the rights were violated would be a half measure, Justice. So we'll accept whatever the court's ruling is, but I think that alternative there falls short. With regards to Wheat says, where a court justifiably finds an actual conflict of interest, that's when the discretion kicks in. Conflicts of interest are different than these rules that the judge is citing here. Because a conflict of interest, the judge is complicit in the ethical violation because she has two appearances representing both parties in front of her. And they're different because we know that that's a situation where the lawyer hasn't fully and fairly advised the defendant as to what the repercussions are on proceeding forward. Absent a conflict of interest, we trust these letters like October 11th from these defendants. We trust that they understand what's going on, that they have cooperated with their lawyers and developed a good trial strategy and tactic to catch that prosecutor off on his back foot on a trial that was supposed to happen in January, and to have a well-developed strategy of third-party guilt. These lawyers knew what they were doing. They had articulated in 100-some pages of briefing. Here's what we see in this case. We're ready to go forward with trial. So conflict of interest doesn't apply, and that's what weak is clearly about. Conflicts of interest are different. And this court would be one of the first court in Indiana, for sure, if not the first court in the nation, to say that we treat all kinds of ethical violations like pretrial publicity or the inadvertent violation of a discovery order as something on the same level as Wheat's conflict of interest. That's unheard of, and this court should not be using the original action to create new law like the judge wants us to say here. Justice Masson, Justice Goff, and Justice Slaughter, you'd asked me a question about ineffective assistance of counsel. I'm clouded sometimes by my judgment because the rules that the judge cited here aren't ineffective. But absolutely, a defendant could waive a claim of ineffective assistance of counsel on the record, and that's what our conflict of interest case law establishes. If you pull the gentleman in and you explain to him what your concerns are, what's going on, and make sure that he knowingly and voluntarily knows what's going on and wants to proceed forward, yes, you can waive an ineffective assistance of counsel claim. So if a client wants to represent himself, he can waive his right to effective assistance of counsel if he knowingly and voluntarily says, I want to go forward and do this on my own. So my troubles with answering that question is I feel so passionately, and Mr. Allen and attorneys Rosie and Baldwin feel so passionately that what the judge is talking about here is zealous advocacy, defending the rights of their client and trying to get this thing to trial quickly. And the reasons that the judge is stating in her brief, which are a little different than the reasons on the record, but none of those are what we see as being related to ineffective assistance of counsel, or would even, if proven to be something wrong, aren't going to meet the Strickland prejudice wrong. So, but yes, if these things could ever arise to ineffective assistance of counsel and justices, I'm not conceding that. But if they could, hypothetically, yes, you can bring the defendant in and he can waive those rights. But that's not what we have here. In the end, Your Honors, the judge exceeded her jurisdiction and refused to accept Rick Allen's wishes when she had an absolute duty to act upon them, and there's an emergency that exists. I think when those things are before this court, there should not be a question as to whether original action exists. And there is more clarity than we see in records across this state as to what this gentleman's wishes are. They are undisputed. And I think that the judge had an absolute duty to recognize what he wanted, go forward with trial in January, and this case should be heard in Carroll County today rather than before the Indiana Supreme Court. But I appreciate your time and consideration. We ask you to grant the relief we requested. Thank you very much.
Thank you, counsel. I want to commend counsel on both sides. Just excellent briefing, excellent argument. We will be discussing the case and getting a decision as quickly as possible.
All right. He got 4.5 minutes uninterrupted closing argument. I have to check with Steve Gosney, but I do think that is a good sign. I will make no promises, absolutely no promises, because we don't know how they will rule. But 4.5 minutes of uninterrupted closing arguments towards these justices is, in my opinion, a really good sign. But, oh, that was interesting. How the state, in form of Judge Gould's representation and the Attorney General's representation, all they had was wheat, the wheat case. And one of the judges specifically told them, give us something else than wheat. And they couldn't. For me, that is very telling on the absolute weakness on the state's opinion, in my opinion. Again, absolutely no guarantees whatsoever. Gigi says, that's better than I've ever seen in a court like this. Okay. I trust Gigi on her words. I will check in with Steve Gosney if he, and for you who don't know, Mr. Steve Gosney is a Florida-based death penalty approved appellate lawyer. I want to talk to him and check with him if he have ever heard anybody getting 4.5 minutes of uninterrupted closing arguments before a Supreme Court. With that, thank you all so much for showing up. I didn't think this would be televised, so I haven't planned for this at all. I know that Mo will do a video or a stream about this once she's been at the dentist, so she's numb up to her eyeballs and couldn't join us. And go over to Mo in the deep end, subscribe to her. She has done more in-depth in the Delphi case than I have. I have a playlist of Delphi case as well with her here, but she is the one with the most in-depth coverage of this case. So I will be watching her as well. Whew. I'm almost a bit so sweaty here. But yeah, thank you everybody again for showing up. Thank you so much. You have choices between Recovery Addict, Alternate Corner, Danny and Direct, Potentially Criminal, but he's covering this as well. And Civil Law, who is also covering this. So if you want to hear more about this Supreme Court, it's a Potentially Criminal or Uncivil Law, or Recovery Addict, Alternate Corner, or Danny Ann. Recovery Addict, everybody says recovery, well, one said. Okay, everybody say hi to Recovery Addict from me. Thank you all for showing up. Thank you so much. See you tomorrow. Bye-bye.